this is being recorded. The participants outside of the study group and staff will not be able to ask the question. But if anyone that's on the call wants to get a question asked and answered, if you will email the, SGG, what I never can remember it, Brooke, Baker.
It is SGGP at governor.alabama.gov.
Yep. Say that again so everybody can get that.
It is SGGP, as in Study Group on Gambling Policy, at governor.alabama.gov.
Yeah. If any of those that are on the listening portion want to get questions asked and answered, do it at that point in time. And as we get into the presentation, we'll ask each of the speakers whether they want to hold questions or have it at that particular point in time. Before we go on any further with the welcome, let's go ahead and call the roll to make sure who is formally in attendance. Baker.
Mr. Ray Almodovar.
Everybody go ahead and unmute so we can get through this pretty quickly.
Here. Ray Almodovar here.
Great to have you on. Dr. Deborah Barnhart.
You know, I tried to call her yesterday, voicemail full, and I texted her yesterday afternoon. I haven't heard from her. She may be out of town or out of the country.
Mr. Walter Bell. Mr. Bell, are you on?
Unmute.
He was on earlier. It's not showing he's back on. Let me see. Dr. There we go. Dr. Regina Benjamin.
Present.
Mr. Young Boozer.
Here.
Sheriff Sam Cochran.
I'm here.
Ms. Liz Huntley.
She was here.
Mm-hmm.
Unmute.
You may have her muted there, Baker.
Her name's.
Okay, now here. It was saying the host had muted me. Okay.
Yep.
Baker, can you leave us all unmuted and we'll mute it from our end?
I have done that. Thank you. Will do. Mr. Carl Jamison.
Here.
Justice Jim Main.
Present.
Mr. Phil Rawls.
Here.
Mayor Todd Strange.
Accounted for here.
And Dr. Mike Watson.
Unmute, Bishop.
Now, how about that?
We got you.
All right. I was trying to unmute, and it was saying that I was muted there. I'm here.
All right. The
before
roll's
we
been
go-
taken.
Good, thanks. So Deborah's the only one that we do not have on. Regina, I don't know whether you own, when we were talking about earlier, the fire, they said that, was it down in your neck of the woods that the fires have been going? Regina?
She's muted, I think.
All right. Well, let's welcome all of those that are.
I'm sorry, I'm back now. Baker, I keep getting muted. Sorry. Can you just kind of watch it a little bit? It just keeps automatically muted.
I can.
Okay. Yeah, those fires are down there, and hopefully Sam has got them taken care of.
He's a volunteer fire captain too.
That's right.
Okay. Well, let me officially welcome us to the third public meeting, the second via Zoom. And we appreciate the presenters that are going to be presenting today, both the lottery piece as well as the tribal gaming from the Interior Department, for being able to do this. I think from their perspective, at least, we've been told it was helpful for us to be able to do that. And it worked fairly well the last time. We've talked about the muting. If you want to ask a question, be sure you get unmuted, but keep it muted at those other times. We've also said if any of those that are in the listening mode want to have questions asked, to email the website or the email address that we have, and we'll get those asked and answered. I will remind everybody that we are being recorded as of a few minutes ago. And so with that, I would like to at least formally welcome a new face to the group, Brooks McClendon. Many of you know, the study group does, but those that are listening, Baker Allen in the policy organization has been kind of staffing this and a wonderful job, great institutional knowledge. Fortunately for him, unfortunately for us, he's taken a position with another quasi-government organization and will be leaving at the end of the month. And Brooks McClendon, who is in the Legislative Affairs Office, is not, as I understand it, coming over to policy, but will in fact be assigned to continue staff this particular group. We've met together, he and Baker are meeting. We met yesterday jointly with Joe Bonner, and he's a bright young man. He's been around for a while. He has a great history in the political process, so we know that he'll carry on in Baker's traditions. I want to at least welcome Brooks officially to that and let everyone know who's interested, media as lobbyists as well, that Brooks, as of, I guess after next Friday, will really be the point of contact in that. So with that, I think it's appropriate now to move into the presentations, unless some of the committee has other things they want to say. Brooks, you want to say a hello to everybody?
Sure. Thank you, Mayor. I look forward to working with this group. I've shared my contact information with the study group members. Feel free to reach out to me anytime. And Baker's set a pretty high bar, but look forward to working with you.
We know you'll jump over it. Well, let's get started. The first presentation this morning will be on tribal state gaming compacts. And I don't know what order or who's going to do it, but according to my notes, Paula Hart, Director, Office of Indian Gaming, the Office of Assistant Secretary, Indian Affairs. At least she's listed first. So Paula, if I can, let me just leave it with you. And as you want to introduce others that have a part in this presentation, we can do that. And if you would just perhaps, when you're speaking in the beginning, just give us a 30-second kind of update as to where you are and who you've been and what your responsibilities are, so that we could just put that into some context. So welcome. We appreciate your willingness to do this.
Okay, good morning, and thank you. Thank you for having us. And Baker has been very, very helpful and a very professional and easy to work with. So I can see how you guys are going to be missing him. My name is Paula Hart. I'm the Director for the Office of Indian Gaming. I've held this position since February of 2010, so just over 10 years now. Prior to that, I was also the Deputy Director and had held other positions within the office. I started my career in the gaming office, reviewing tribal state compacts. So this is truly my area of expertise, and I've probably read every single compact nationally. So let me let you know our office is the Office of Indian Gaming. I do want to make one little remark here. The study group reached out to the National Indian Gaming Commission. And as I was looking at our PowerPoint, I thought, maybe we should first start out with what is the difference between the National Indian Gaming Commission and the Office of Indian Gaming. The Office of Indian Gaming was delegated responsibilities by Congress to the Secretary of the Interior. And the Secretary of the Interior created the Office of Indian Gaming to promulgate those issues that the Secretary was given. The NIGC was also created by Congress in the Indian Gaming Regulatory Act. And the easy rule of thumb is NIGC has authority over Class 2 gaming, which we'll get into later, and Class 3 gaming, which comes to the Department of Interior, our office. So that's the shorthand here is that NIGC does Class 2 gaming, and the Office of Indian Gaming does casino-style gaming, Class 3 gaming. We are relocated within the Assistant Secretary for Indian Affairs at the office in the Department of Interior. Next slide. As I said, I was the director. I have a deputy. This is the staff in the office. We have, there's 7 of us. I have a deputy director. On the line today will be my senior policy advisor, Troy Woodward. Troy is my main person dealing with issues regarding tribal state compacts. I have a policy advisor, Phil Bristol, a management analyst, 2 management analysts, and management assistant. Morgan Oakes is on the line also. Morgan, I had come on the call because she is the first line if you have questions or if you call in for any specific gaming reasons. Morgan will be the one answering the phone, and she'll be the first person that you're in contact with. So I thought it was helpful if you guys knew who she was and if she knew who you guys were. Next slide. The delegated responsibilities to the secretary were, and this is just kind of a shorthand list of what it is our office does. And I think you should look at this as compared to what the National Indian Gaming Commission does. Our office does the tribal state compacts. We do revenue allocation plans for tribes. We do the land applications for gaming. We do gaming contracts and collateral agreements under Section 81, 25 U.S.C. 81. We also respond to congressional correspondence. And like this, we provide technical assistance to tribes and states. And we also do applications for secretarial procedures. I will turn this over now to Troy Woodward. And Troy's gonna go into a lot more detail in all of these areas. Troy?
Good morning. Can we go to the next slide, please? I've been working at the Office of Indian Gaming since late 2012, but I've spent my entire career, I'm a licensed attorney, and I've spent my entire career in the field of federal Indian law and Indian gaming. I wanted to discuss briefly the early days, how we ended up with Indian gaming, and then I want to segue into the types of gaming that's available, Class 1, Class 2, Class 3, talk about specifically about compacts and what is and is not allowed in a compact. We'll talk about some issues that are prohibited in compacts, and then we'll talk about what is specifically included in IGRA regarding compacts. So in the early days of Indian gaming, it started with tribes that were conducting bingo type games on their reservation. And in those early days, the tribes and the states where they were located had a disagreement over who could regulate gaming on tribal lands. The tribes, of course, believed that since they were on the reservation that they should regulate. The state believed that since they were located within the state that the state should have regulatory authority. The disagreements led to litigation, which as the litigation was decided, as those cases were decided, they ended up kind of being the backbone of what became the Indian Gaming Regulatory Act. Now, I sort of have to apologize. Many times in our office, we say the Indian Gaming Regulatory Act so many times, we have to have an acronym for it. So we call it IGRA. So every time I'm saying IGRA, that's what I'm referring to. So in that early California case, the state attempted to apply its civil regulations to the tribe's bingo. And the California statute did not entirely prohibit playing bingo. What it permitted was for charitable organizations to have bingo games, but they had to be operated and staffed by members of designated charitable organizations. And any profits derived from the games were to be kept in special accounts and only used for charitable purposes. California asserted that the bingo games that the tribes were operating violated each of those restrictions, and the state insisted that the tribes comply with state law. What initially happened when they went to court, the district court made a distinction between civil regulatory and criminal prohibitory laws. And it came down to this: if a state allows some gaming and doesn't entirely prohibit it, then the state really is regulating gaming. And if it's civil regulatory, then the tribes have authority to do it. If in the state it's entirely criminally prohibited, then the tribe, the state could regulate it. In that case, as far as we know, there are only 2 states in the United States that entirely criminally prohibit gaming. One is Utah and the other is Hawaii. Most other states allow some form of gaming. Next slide, please. There was another case similar to the California cases that came out of Florida, and it was the facts were very similar, and both the Cabazon case, which I mentioned before out of California, and the Seminole case went up to the circuit courts and eventually ended up in the Supreme Court. In the Mashantucket Pequot case, it was the same thing. The tribe was offering gaming and the bingo, and usually it was high stakes bingo, which is, I think, why the state was concerned about regulating it. And in the Mashantucket Pequot case, the tribes went to court and sought an injunction to preclude the state from enforcing any state statutes. So these cases ended up before the Supreme Court in the Cabazon case. And while the Cabazon case was pending review, but before it was decided, Congress enacted the Indian Gaming Regulatory Act. Next slide, please. So IGRA was enacted as a result of those cases that the tribes actually prevailed in that litigation. Seminole v. Butterfield coming out of the 5th Circuit, Cabazon versus California coming out of the 9th Circuit. And after IGRA was enacted, the Cabazon case came out, and they basically said that tribes have the authority to regulate gaming on their reservations. But because Congress had been working on this issue for a while, and they incorporated many of the principles that the various district courts and the circuit courts discussed in examining who should regulate gaming. Next slide, please. So after IGRA was decided, one of the key points involved what we call scope of gaming. And it's what gaming does a state actually permit? So in the Mashantucket Pequot case, the federal district court in Connecticut held that under the Indian Gaming Regulatory Act, a tribe can conduct Class 3 gaming if it's located in a state that permits such gaming. And it actually expanded on that and said if it allows such gaming for any person, organization, or entity. And the distinction that ended up being key in the Mashantucket Pequot case was that Connecticut allowed nonprofit casino nights. So it was a mechanism for raising money for charitable purposes. And what they did is they allowed the full gamut of casino games, but all the money would go toward charitable purposes. And the court, in its holding in the Mashantucket Pequot case, said that because Connecticut permits that gaming and doesn't actually prohibit it, the tribe would be allowed to conduct that gaming. Next slide, please. So if a state regulates a type of game, it doesn't prohibit that game, then it cannot prohibit the game in a Class 3 compact. And even if the state's regulatory provision contains some criminal penalties, it still doesn't mean that the state criminally prohibits it. It still is gaming that's subject to compact negotiation. Next slide, please. So when Congress enacted the Indian Gaming Regulatory Act, they classified gaming into 3 classes: Class 1, Class 2, and Class 3. And Class 1 gaming is traditional social games that have been played by tribes since time immemorial. Tribes have been engaged in gaming, whether it's stick games or other types of gambling, horse races, whatever. Tribes have been engaged in that for a very long time. Next slide, please. The next type of gaming is Class 2 gaming. And the Indian Gaming Regulatory Act has a fairly well thought out and very detailed definition of what Class 2 gaming is. So the backbone of Class 2 gaming is bingo, but there are also games that are associated with bingo that are also Class 2. And then there are some, as you can see in the definition, that there are criteria that you look at to see how it fits into Class 2. Class 2 also includes card games that are specifically or explicitly authorized by the laws of the state, or that are not explicitly prohibited by the state and that are played in the state, but only if those card games are played in conformity with state laws. The term Class 2 does not include any banking card games. So blackjack, the IGRA specifically says including baccarat, chemin de fer, or blackjack. And then it specifically does not include an electromechanical facsimile of any game of chance or slot machines of any kind. Next slide, please. So Class 3 gaming doesn't have its own definition in IGRA, except that it is anything that is not Class 1 or Class 2 gaming. And if a tribe has Indian lands as defined in the Indian Gaming Regulatory Act, the tribe can conduct gaming on those lands. If the gaming is Class 2 gaming, the tribe and the National Indian Gaming Commission regulate. If it's Class 3 gaming, a tribe and a state determine how it will be regulated, and they do that through a tribal state compact. Next slide, please. So compacts require the participation of 3 sovereigns. It requires the participation of the tribe, the state, and the federal government. Tribes don't need a compact if they're engaged only in Class 2 gaming. But if they want to engage in Class 3 gaming, they have to have, in addition to a compact, they have to have a tribal ordinance that governs gaming. They also need that for Class 2. And a tribe's gaming ordinance has to be approved by the National Indian Gaming Commission. For Class 3 gaming, a tribe also needs a valid tribal state compact negotiated between the tribe and the state. And that has to be approved by the Secretary of the Department of the Interior. Next slide, please. In this quote that's up on the screen, Senator Inouye is essentially saying that Congress did not intend for compacting under the Indian Gaming Regulatory Act to be used as leverage to include issues that are not related to gaming. In his quote, he specifically mentions taxation, water rights, environmental regulation. And we see that every so often when compacts come in front of us. Next slide, please. So as I mentioned earlier, IGRA specifically permits certain things in the compact. As you can see on Roman numeral 1 here, the tribe and the state determine between them what criminal and civil laws and regulations will govern tribal gaming. This varies in the compact. The state and the tribe decide that entirely between them. In Michigan, for instance, every tribal gaming facility has a sign near the entrance that says this facility is regulated by the laws of the tribe, whatever tribe that is. And they've got a number of tribes in Michigan. In some other states like California, Louisiana, the state is more involved in regulating. In other places like California, it's a joint regulation between the tribe and the state, and it's spelled out in the compact. But the key here is that the provisions have to be necessary and directly related to gaming. And the second Roman numeral bulletin here, the tribe and the state will agree who has jurisdiction to enforce the laws. The tribe and the state can allocate criminal and civil jurisdiction between them that is necessary for the enforcement of the laws and regulations. And then the third Roman numeral point here, that if there are costs that the state incurs in regulating gaming, then IGRA allows the tribes to help the state defray those costs. Next slide, please. So these are other issues that are specifically allowed in a compact. So Roman numeral number 4, IGRA specifically allows for tribes to include in the compact elements of tribal taxation. They have to be comparable to those assessed by the state. In fact, we rarely see instances where tribal taxation is included in a tribal state compact. And just to be clear, these are taxes that the tribe would impose as part of revenue collection, not that would be imposed on the tribe. Moving on to Roman numeral number 5, the compacts can include remedies for breach of compact or breach of contract, it says in IGRA, but they're specifically talking about if there are breaches to the compact. And these are usually enforceable by mediation or some type of agreement by the parties to get together and discuss the disagreement. They can be enforceable by injunction in a court of competent jurisdiction. And number 7 is kind of a catch-all. I wanted to highlight that because 7 says you can specifically include in a compact any other subjects, but the limiting factor is that are directly related to the operation of gaming activities. Our office, as Paula said, our office reviews tribal gaming compacts. We read through the entire thing and we verify that the items included in the compact are directly related to gaming and necessary to regulate. Just as a note, we provided a couple of letters to Baker early on that I would recommend that you take a look at. One involves a tribe in Massachusetts and its agreement with the state that we ultimately disapproved that compact, and we disapproved it in a letter that discusses in a lot of detail why we're disapproving the compact and what provisions specifically violated IGRA or other provisions of federal law. We also included a letter to a tribe in Arizona that discusses the provisions that are not directly related to gaming, and I would recommend that you take a look at those letters. Next slide, please. So the Indian Gaming Regulatory Act has a provision that prohibits a tax, fee, charge, or other assessment being required, the tribe being required to pay that. IGRA limits payments by tribes to states except for those state costs resulting from the tribe's gaming. For instance, if a tribe's gaming facility increases local expenses, for example, police or maybe emergency services, maybe road use, in those cases, the tribe can pay the local governing body to help defray those expenses. We've also seen examples, however, where a state has extensive Las Vegas style gaming, and in order to enter into a compact with a tribe, they ask the tribe to pay a certain amount of money to the state. And in that case, we think that would be a prohibited tax or fee on the tribe. We've also seen instances where a state that has fairly extensive gaming asks the tribe to foot the bill for the entire problem gambling mitigation programs in the state. And we think that should be shared between the two. Not that the tribe shouldn't pay, but that if the tribe is forced to pay for the whole thing, that it would be a prohibited assessment. Next slide, please. If the tribe and the state reach an agreement and submit a compact, the department is actually fairly deferential to those two sovereigns that have sat down at a table and negotiated a compact. And Congress says that the department can only disapprove a compact for very specific reasons. The specific reasons are, of course, if it violates the Indian Gaming Regulatory Act or some other provision of federal law not specifically related to jurisdiction over gaming on Indian lands, or if it violates the trust responsibility of the United States to Indians. I just wanted to highlight a couple of provisions in the Massachusetts letter. This was the Mashpee Wampanoag tribe and the Commonwealth of Massachusetts negotiated a compact and sent it to the department. I think this was in 2011, 2012. And we reviewed the compact and we disapproved the compact. And when we disapproved it, we sent a letter to both the governor of the Commonwealth of Massachusetts and to the chairman of the Mashpee Wampanoag tribe. Our first issue that we had with the compact was that it provided a significant share of the tribe's gaming revenue to the Commonwealth, which undermined the central premise of IGRA, that Indian tribes should be the primary beneficiary of Indian gaming. The second thing that we noted was that the tribe and the state attempted to use the compact negotiation process for a host of other issues. They tried to include the tribe's hunting and fishing rights, tribe's land claim, other issues that were clearly a violation of IGRA's restrictive purpose. We found out later that the tribe was actually asked that those, like the hunting and fishing and the land claims issues, be included in the compact. But nevertheless, we disapproved the compact based in part on the inclusion of those because they were not directly related to gaming. And the third thing that we mentioned that in that letter was that the Commonwealth sought authority over activities that were not related to gaming, such as they sought to regulate non-gaming suppliers, non-gaming related entertainment services, other non-gaming amenities. So those issues we thought were included. They were not directly related to gaming and contributed to the disapproval. So when a compact comes in, the secretary basically has three options. The first is to approve the compact. The second is to disapprove the compact. Or the third option is if we don't approve or disapprove within 45 days, then the compact is deemed approved after the 45th day. Now, the distinction between approval and disapproval has developed in that an approval carries an affirmative statement that we've analyzed the compact and we find that it complies with IGRA, with the Indian Gaming Regulatory Act. By contrast, a compact can be deemed approved, but if it's deemed approved, which means it goes into effect after the 45th day, it means it's only approved to the extent that it's consistent with the Indian Gaming Regulatory Act. Next slide, please. So our regulations require that both the tribe and the state certify that a compact that they've entered into has been validly entered into. For the tribe, we require, or we ask the tribe to provide a tribal resolution certifying that the signatory to the compact has the authority under tribal law to sign the compact. Likewise, for the state, we ask for certification that the signer, usually it's the governor, but not always, that the signer is authorized to enter into the compact under state law. That seems like a fairly elemental requirement, but we have had cases where there's a disagreement in the state about whether the governor has the authority to sign. We haven't seen that as much with tribes, but early on in the early 90s, there was a disagreement in the state of New Mexico where the governor negotiated a compact and sent it to the department for approval. And in the meantime, a state legislator filed suit, which ended up in federal district court. And the state legislator asserted that the tribal state compact required legislative approval before it could go into effect. And in that case, he actually won the case. And there was a subsequent federal case that invalidated the compact that the department had approved. Now, one of the things that we also look at is whether or not, if a tribe is going to be providing money to the state for reasons other than costs incurred by the state in regulating, we want to make sure that there is a valuable economic right being purchased by the tribe. So if a compact provides a valuable economic benefit to the tribe in exchange for that payment to the state, we have a solicitor's opinion that said that's not a tax fee charge or assessment. It is in fact allowed by IGRA because the tribe is purchasing a valuable right that it might not otherwise have. So some states.
Troy, may I
Yeah.
may I interrupt you and ask a clarifying question on that point, please?
Sure.
Because this is Todd Strange. You made it clear that the payments that the tribes make are for costs associated with gaming.
Right.
And so if in fact there's additional cost by governmental entities to assist in the gaming revenue to the tribe, and all the state gets back is in fact the reimbursement of those costs, where is the valuable concession?
Yeah, so that's a good question. So early on, we had a compact come in between the Mohegan tribe in Connecticut and the state of Connecticut. And in that case, the state of Connecticut did not allow Las Vegas, commercial Las Vegas casinos or Las Vegas style casinos.
Troy, let me interrupt for a minute. Mayor Strange, I think what you're asking is the distinction between a regulatory cost and revenue sharing.
Yes.
So there is absolutely regulatory costs, which are just reimbursable fees. Revenue sharing is when so say for the state of, say your state, you want to limit gaming. You don't want a gaming facility on every corner. What you can do
Right.
is you can go and you can negotiate a compact with the tribe, and the tribe can then pay you a percentage of the revenue.
Okay.
But for that payment, because it's not a regulatory cost, for that
Right.
payment, for that revenue sharing, the tribe has to get something of value because you can't just tax them. So
I
the
do
difference is one's regulatory and the other one is actual revenue sharing. And for revenue sharing, there has to be a valuable concession.
And it's not a tax. It's not a tax. It's just revenue sharing. Got
It's
it.
revenue
Thank-
sharing because there's a valuable concession and therefore not a tax.
I do understand that. And Paula, thank you for that explanation.
I have
Okay.
a
I'm
follow-up.
sorry, Troy.
I have a follow-up question on that, if that's okay.
Uh-huh.
Who determines the sufficiency of the value and how is it measured?
So what we do is when we get a compact that has revenue sharing, we send a letter to the tribe and the state, and we ask them to justify the revenue sharing. We ask them to explain to us what economic value is the tribe getting from this revenue sharing. And usually the tribe and the state submit an economic analysis that shows this is the benefit the tribe is deriving from it, and the tribe wouldn't otherwise be able to get that benefit if it didn't wasn't paying for it.
And usually if a compact comes in and it has revenue sharing in it, the tribe and the state have both agreed to that revenue sharing. So the economic analysis from both parties is usually pretty similar. And like Troy said before, if a tribe and a state have agreed to that, and they submit an economic analysis to prove that it is worth what the value is, that we would consider that as valuable consideration and therefore accept unacceptable revenue sharing.
Troy, are you close to wrapping up? We want to give enough time for questions and answers.
Yeah, I've got just two more slides briefly.
Okay, please. Thank you.
So, and this one is I touched on this briefly before, and it's the 45-day review period. And Congress built in for the federal government a fairly quick 45-day review period. And if a compact isn't approved, can you go to the next slide, please? If a compact isn't approved or disapproved within 45 days, then it's deemed approved, which means that it goes into effect once we publish notice of it in the Federal Register. The only limitation on that is that it's in effect to the extent that it's consistent with IGRA and with other federal laws. All right, and for the last one, Morgan, I'm going to turn the time over to Morgan to explain this last slide. Go ahead,
Sure.
Morgan.
Good morning, everyone. My name is Morgan Oakes. I'm the management assistant for the Office of Indian Gaming. So my role with the office is I answer phone calls. I schedule meetings for the office. So if you want to schedule a meeting with our office, I would be the one you would contact for that. I'm also the first line of questioning for phone calls. If anyone calls in with any questions, I can answer the ones that I'm familiar with. Otherwise, I'll punt them to Troy and he can take over from there. I'm also the first line of review for compacts and issue spotting. So I review to make sure the compacts include state certification as well as tribal certification. And I'll date stamp the compact, triggering the 45-day time clock and circulate to all of the approvers. This concludes my short portion of the presentation, so I'll just turn it over to
Megan, before you leave on that one, I did have a question on the 45 days. Is there any extension of the 45 days if you're in conversation with the state and or the tribe relative to the provisions, or is it just a cut and dry 45-day yes or no?
Troy, you want to take that?
Sure. So the tribe and the state, the 45 days is a pretty hard deadline for us. But if the tribe and the state are still negotiating, our regulations allow them to ask to withdraw the compact so that the 45 days doesn't run out.
No, I was really speaking about your organization and the state. So it's either yes or no in 45 days.
Yeah, it's a hard deadline. Yeah. And there's one other slide that just has some additional information if you would advance the thing. And the only thing I want to say about this is that the address is very important. We've had compacts that were sent to the National Indian Gaming Commission, some that were sent to the secretary, and like Morgan said, the 45 days doesn't start until she stamps it. So it's important to get it to the right address. So that concludes my presentation. Thank you very much.
Paula, Troy, Megan, thank you, Morgan. Thank you so much. Very enlightening. We, in fact, do have your presentation. I believe we even have some of the letters that you referenced that was sent in our pre-material. There was 170 pages that we got 2 days ago. So suffice to say, we haven't been through every line of that. So this is a good opportunity to have that short summary. Questions from the study group?
Let me jump in here with regards to compacts.
Introduce yourself, please.
Oh, yeah, I'm sorry. Young Boozer. And I am interested in the compacts themselves. Is that I have looked at a number of different states, and I've read through the compacts that the states have with the tribes. And it looks to be a standard uniform agreement. Is that the sections are all common. The wording is sort of per the standard. And I wondered if that is the way they are designed, or if that is the correct impression.
Troy?
Yeah, so it varies from compact to compact. The tribes in the state, we don't have a model compact that we recommend, and it's entirely up to the tribe and the state what goes into the compact.
However, let me also say that because everybody's trying to regulate the same thing, and it's just a matter of which different types of games, they do all tend to seem to becoming more and more alike. You're correct.
Okay.
But that is not, that is purely just because of the circumstance. The tribes and the states absolutely negotiate individual compacts.
But we could take a lesson from what we read, and that is if we follow the structure of current compacts that are in place, or ones that have been negotiated recently, that should give us the guidelines for what we should be addressing in each one of these.
That is correct.
Okay.
Yeah.
Thank you.
The only thing I would add is that we have all of the compacts, well, most of the compacts on our website, which is the web address is right there on the bottom of that last slide. I would just recommend you look and see if the compact has been affirmatively approved or deemed approved, because affirmatively approved means we've gone through it and we've approved of all the provisions.
This is Liz Huntley. I had a question about the revenue sharing option, and you discussed and went into great detail about each one determining their sufficiency of value, and both this tribe and the state doing an economic analysis. Can you describe an instant where there's been a disagreement on what that economic analysis, what those numbers should be?
Troy, can you talk about the Rincon case and the disagreement there and how the revenue sharing in Rincon ended up?
Sure. What Paul is referring to is a case out of California that ended up in federal district court, and then it went up to the Ninth Circuit involving the Rincon Band and the state of California. In that case, the tribe had an existing compact, and they were authorized to have a certain number of machines. The state had a gubernatorial election. A new governor came in, and he believed that the state should be able to get more money from Rincon than they were paying. The tribe objected. The tribe wanted more machines, but was not willing to pay what they thought was an exorbitant cost. In the litigation, it ended up that the court looked at a couple of things. They looked at the amount that the state was asking and whether it was a negotiated agreement or whether it was a demand by the state, take it or leave it. And they said it was a take it or leave it demand by the state. And the second thing was that the money wasn't going to anything related to gaming. It was just going into the state's general fund. And because of that, because of those two factors, a take it or leave it demand and the money going into the state's general fund, it was considered a tax, and the court ruled in favor of the tribe.
And then I'll give you another example out of Oklahoma. The Oklahoma compacts came in. We knew some of the tribes, and what they did is they had, of course, there's a number of tribes in Oklahoma. What they did is they had some tribes were able to send in economic analysis that proved that this was very good for them, and that this would be a very good agreement, and they agreed with the revenue sharing. Other tribes realized that this may not be good for them, but it would be the only compact they could get. And then there was a third set of tribes that said, you know, hey, we don't know. So what we decided to do is, because we try to really help the tribes and states work together. So in Oklahoma's case, what we did is if the tribe and state submitted an economic analysis that supported the revenue sharing, we approved the compact. If they didn't say anything at all and basically wrote in and said, listen, we don't know if this is good for us or not, but we know this is the best that we can get, the best deal that we can get, then we allowed those to go into effect by operational law. They were deemed approved. And then if the tribe wrote in and said, this is a bad deal for us, it's going to bankrupt us, whatever, sent us an economic analysis that proved it, then those would be disapproved. So in that case, in those compacts, although they were all the same for every tribe, each individual circumstance determined the outcome of the compact.
Any other questions? I got to tell you, I know a lot more today than I did before you started about 45 minutes ago. As you well know, we are a volunteer group that the governor has asked to look at this and provide some recommendations. We have no authority, so it's going to be up to the governor and the legislature and ultimately the people. So hopefully you might hear from us in the future, but we're very grateful for spending your time, and thank you for the job that you're doing, particularly in Alabama, but elsewhere as well. So anything else for this group from the study committee? Well, thank you very much, Paula and Troy and Morgan.
You're welcome, and we certainly put it out there that we are here to help the tribe and the state come to an agreement. So anytime we could help provide technical assistance to both the tribe and the state, we're very, very much willing to do that. So thank you for inviting us, and good luck on your study group.
I suspect Morgan will be answering the phone for us in the future. Thank you so much. Appreciate it.
Okay.
All right. Thank you very much.
Okay.
Good.
Bye-bye.
Let's go to the next. The title is Common Questions When Considering a State Lottery. David Barden, CEO of the New Mexico Lottery Authority. David, I'm assuming that you're on the line, and we appreciate your patience. If you were listening to the previous presentation, and obviously we're interested in the lottery. Our surrounding states appear to do fairly well with the lottery. We tried it 20 some odd years ago, didn't succeed in a vote. So we're delighted to hear from you with what you have to offer to us. So with that, if you could tell us a little bit about yourself and start your presentation.
Thank you, Mr. Chairman. I have to tell you, it's fairly intimidating with the group I have before me today to give a presentation. So the who's who of Alabama, it looks like from your list. So thank you for having me today. I too am a licensed attorney by trade, or not so much in practice anymore, but I also had a time in my life where I dealt with compacts. So I found the previous segment very interesting, and being from New Mexico now, where the court overturned the governor's compact a while back, we understand what goes on. I'm the CEO of the New Mexico Lottery Authority. We're set up as a corporation, which I think is the right way to go. I've served there since November of 2013 as the CEO of that organization. I served in various positions with the Multi-State Lottery Association. I've been chair of the Powerball Group, which basically oversees the Powerball game that you'll probably want to join at some point if you proceed with the lottery, I would hope. I know that's where most of my friends like to buy their tickets, or the bigger jackpot games. But anyway, I've chaired several other smaller games with the association also, and served as a NASPL officer and done many, many things, but I'll move on from that. I'm sure you've talked to NASPL people before, but I would tell you before I leave compacts, make sure that if you draft your compact, it does not have an impact on what the lottery's ability to do as a business is. I know we have some questions in New Mexico about that because of the drafting of the current compact. So I would just remind you and tell you to jot that down and remember it at a later date. I started with the lottery back in 2000 in South Carolina. I'm a South Carolina resident. I grew up a small town Southern Baptist, so I know many of the obstacles that come from being in a southern state and growing up in a southern state. We had a very successful lottery in South Carolina. When I left South Carolina, the sales per caps were always in the top 5. It's fallen a little bit since I've been away, and I like to talk to my friends who are still there and sort of rag them about that since I've left, they've fallen slightly, but they still have very excellent caps. In 2009 or 10, I went to Arkansas and helped start the Arkansas Lottery, which was considered by many to be the most successful startup in the lottery world. We put about $30 million in the bank 4 months early, and probably was the fastest lottery startup ever. So a lot of experience with that. I've also been legal counsel to the South Carolina Senate, where I've drafted legislation and doing or listening to things that you're listening to today. Also assistant director of the Department of Public Safety, which is the biggest law enforcement agency in South Carolina at that time, about 4,000 people. And I started that agency also. So I've had 3 startups with big agencies, and understand what it takes and the amount of time it takes. And I've got a good friend who's a fighter pilot, and he always tells me the key to success is flexibility. So I would tell you, when you think about any of the things you do, think about flexibility and how the market works, and that the lottery really is not set up as a normal governmental entity. You might set it up that way, but it still needs to have flexibility to do things that other state agencies just cannot do. If you would flip to page 2, I'll keep going. As you talked about, you're one of the few states left of a handful that still do not have a lottery. I know I was on the phone with a committee in Alaska about 2 months ago, and they're doing the same thing that you're doing today, trying to go through the pros and cons of a lottery. And as you know from the states that are around you, you have really 4 of the more successful states in the country right around your footprint. And in Florida and Georgia and Tennessee all have very strong per caps, do a great business. South Carolina is about the same size. I think y'all are about 4.9 million, and South Carolina is about 5.1 million in a population base. But you probably have the same geographics and the same diversity of South Carolina. So I would say that when you look at states, you probably want to look at how their sales go in their modeling. There's some things they don't do that probably would make them even have a higher per cap, but those are things you can talk about should you decide to move forward with the lottery. I will tell you, at being chair of Powerball, during a couple of years back when we had one of the bigger jackpots. I can tell you, your citizens are going outside your state to buy Powerball tickets. You'd be shocked at the numbers, and I know in South Carolina, we estimated that we probably had 5% of North Carolina playing in South Carolina at the time. But you need to be very competitive with your games. You need to know that people are playing out of state. That's up to the policymakers. As an administrator, I follow whatever the policy is that y'all come up with as far as where you'd want your lottery to go. So you have some really tough choices, but I'm sure with the names on the group and your diversity, y'all will come up with a good decision. As I said, the states are playing. People, I think the COVID-19, just to touch on this very quickly, has sort of opened our eyes. Even with Powerball, we had to reduce our starting jackpots. You probably read about that in the newspaper. It's about convenience. It's about making it easier to procure whatever you procure. I know I've ordered groceries to my house now. I've never done that before. I do all my banking online. So technology, I would tell you to keep in the forefront of your considerations when you're considering a lottery, and just making a simple purchase convenient, maybe even safe during a pandemic like we're going through right now. As I said, your border sales, you're losing a lot out of state. But if you flip to the third page, please. Lotteries have all sorts of good causes, from funding senior citizens to state parks to education. I've always loved working in states that put education first, and that's because I had to pay my own way to go to college. It took me about 20 years to pay off my student loans, so I feel that in a scholarship lottery like where I work, I'm actually doing something to help a kid have a good start getting out of college, hopefully, and not owe as much money as possibly they could. I think it's very important to educate your citizens, should you have a lottery, on what you're doing with the money. It's almost like driving down the road in some states where they put up the signs that say, your tax dollars at work here. People need to know how many people are being educated. Your money's going to school buses, whatever your good causes are, people need to know. At the end of the day, players want to play to win. And I would tell you, don't forget, the lottery is for the player, but the beneficiary gets the proceeds. So lotteries do have to make sure that their players are happy. When the players are happy, the beneficiaries are very, very happy. If you'd flip to page 4. A little bit about enabling legislation. Y'all will probably weigh in on, if there is a lottery, what type of lottery you think you should have. I would tell you, the enabling legislation really sets the stage for success as a lottery. I'll tell you, in states, once they get their legislation passed, it's very hard for a lottery to go back in and generally get their statutory authority tweaked. So a well thought out plan is a great plan. As I would say, a lottery is just like a business. If I sell 2 tickets, I turn in more money for good causes. Just like McDonald's, they want to sell 2 hamburgers or cheeseburgers, not 1. So if people enjoy what they buy from us, and it really is a consumer-based product that is based on people enjoying what they do. It's like going to the movie theater. You choose to do it, so you have to have a good experience, or you will not continue to buy a lottery, and your successful causes will not receive as much money as they should. But as I said, I think flexibility is the key on how you manage your lottery, and take up the best practices. Whoever you bring in, or whatever group you have to set up sort of the parameters of the lottery, will know what they need. And so listen to your lottery experts. I know the chairman, I read a quote, I think he said, it's like you don't want to recreate the wheel. The wheel already exists, and Georgia had a lottery, and I will tell you, the type of wheel you put on the vehicle actually makes it run smoother. And I know you're in automotive, and you don't want to put the wrong tire on the wrong car. So be careful of what you do and how you do it, because you can have something very successful, or you can have something not as successful as it could be. But and remember, integrity is the key to any lottery success. You have to be transparent about everything you do. It's just critically important that everyone knows where your dollars go and your expenses. If you'd flip to page 5, please. There are 2 basic models of how lotteries are organized, and you can see a state-owned corporation, and state-owned corporations are more recent lotteries and establishment. State agencies are some of the older lotteries that have been in existence. So each have their strengths. I will tell you, it is much easier from a business standpoint to be governed as a corporate entity, so you can actually do things more quickly and respond to the market in a much faster way than you can if you're perhaps a state agency. I know, having lived in state agency life, everything takes a long period of time, where it did in South Carolina, to actually make change occur. So I think it's very important to be as flexible with your corporation. There is one other model that I should mention to you, and that's a private management model. State like Illinois Illinois goes out and they actually go out to bid for someone who comes in and actually runs the lottery. There's an oversight group within that lottery of 5 or 6 people, that all the heavy lifting is done within the private management of that corporation. So just something to be aware of. There are only a couple places that actually do this. And I would tell you, if you probably ask any lottery CEO, they would tell you they want to run like a business, just like you would probably want to run your private business. If you turn to the next page, page 6, on who sells your products. I would urge you, and it's not on this page, but should you get a lottery, do an economic impact study within 5 years startup, just to see how many people you touch, how many jobs you've created, the additional tax income that flows into the state from your lottery sales. And you can see, I'm not going to go over each of the bullets, but South Carolina and Alabama are about the same size. And I would guess that probably Alabama would probably have about 3,300 retailers based on the ratios that we use. 1 per 1,500 people is generally the industry analysis that comes in. There are about 154,000 C-stores in the country, and the lottery ranks 3rd in sales in any convenience store. So it falls behind tobacco and food, and then comes the lottery as far as sales. So right now, the C-stores are missing out on a tremendous opportunity to sell an additional product where they make a fair commission, and we'll get into commissions in a little bit because that's very important also. If you were to bring in a lottery or start a lottery, probably on the low side, if you flip to page 7, you'll probably hire 40 to 50 people to run that lottery. It could be more. There are certain aspects of your business you might want to place with a vendor, or you might want to keep in-house. Field service people across your state, you might want the lottery vendor to do that. They're a little more able to respond more quickly, perhaps, than the state could. Obviously, all those people are hired and live and pay taxes in Alabama. So even though they aren't on the payroll, they are residents of the state of Alabama. And of course, you've probably talked to people around the country already. You know, you would have a top CEO to run the lottery and be accounted, either be appointed by the governor or by a governing board, like many of you are already aware. You'd have several divisions within the lottery, and development, finance, sales, security, and marketing, and information technology are the biggest divisions you would have in the lottery. And obviously, they all sort of flow together. And as I would urge you to find someone who's great in finances, the lottery is a bit different in how we account for things. We give away tickets. It's just a different industry. Your security official, it needs to be someone who is I would say well known in the state, who can help you get up and running very quickly with the retailers. They work very closely with those 3,300 people, and it is a chore to get 3,300 people background fairly quickly so that they can actually sell lottery product for you. And of course, it's a business, so I would say treat it as a business. Sometimes things get lost in the political world, and perhaps the lottery gets tied in with it. But it's essential to have strong managers and bring in someone or a team that has industry experience.
Hey, David, before you leave this slide, the second bullet point, the head person accountable to an appointed body such as board of directors. And then you had the private corporation and the state agency. The gaming commission that we've seen around in the neighboring states, is that the appointed body that you are talking about? Or is that just, I mean, is that another name for the board of directors? Or is a commission the same as a state agency?
That's a great question. Tennessee is operated by a board. Georgia is operated independently also. I don't know their exact names, but there are state entities that come under the revenue department, obviously, which would be probably a gubernatorial appointment in some fashion. So,
but this bullet says private corporation appointed by the governor or legislature. That could be called the gaming commission.
it could be, depending on
Okay.
how the legislation is drafted.
Right. Understand. Okay. Thank you.
Which makes it hard. Every state is a little bit unique in what they call their entity. So you will see them named many different things, boards or commissions. Great question, though. Page 7, we just went over the number of people needed for the lottery. Like I said, I would urge you to do an economic impact within 5 years so that you can see how many new jobs are created in the convenience industry and with your retailers, the tax dollars that are coming in, the professors, perhaps if your money is going to education, that are being hired at the universities. All that has a tremendous impact on the state and the growth of the state. You could flip to the next page, page 8, on compensation. I will tell you, throughout the country, retailer commissions vary. They go from about 5% to about 7%. I would tell you, one of the things you might want to look at is having a flexible compensation rate. I think in today's marketplace, you might have certain retailers that don't want to sell your whole portfolio of product. They might want to sell Powerball tickets or online games. You perhaps would not want to pay them the same commission that you paid somebody that carried your full line. You have a question, Mr. Chairman?
No, thank you.
Okay, I thought I saw your light come on, but
What,
anyway.
this is Liz Huntley. What did you just call the flexible option?
I'm just saying with your retailer compensation, you might want to have a more flexible option instead of a straight base percentage for each retailer. You actually might want to tier that. So if someone only wants to do Powerball games or draw games, as we call them in the industry, and not want to sell scratchers, it is a lot less time consuming for them. You might want to pay them 3% versus 7% for someone.
And do you know, as we sit here, examples of states that use a tiered option versus a straight commission?
I think Georgia has some sort of tiered option. States have started looking at it because we have vendors or retailers who actually don't want to sell all your product. They only want to sell scratchers, or they want to sell online. And most lotteries actually require a retailer to carry their full portfolio of games. But as sort of times are changing, we need to be able to be more flexible in how we engage retailers and what retailers we engage, because soon we'll be going to a structure that would allow a Target or another company to actually print a Powerball ticket right off their terminal. So things are changing within the industry as far as our requirements for selling a Powerball ticket. We have standard stock right now that we use, but if you go to Dollar General in Texas, you can go in and buy a Powerball ticket on their plain white paper, and it's a certified ticket. So I would just say, once again, flexibility with what you do, because when you come out of the gate with it, your retail association will be a very strong lobby and have a strong interest in this. So you probably want to have a good plan that you can explain to them if you do anything different than offer a commission. And the reason, and it's very important to even think about this, is in South Carolina, which I think is going to be a state that you need to look at very closely, the commission is 7%. South Carolina does not sell a $20 product. They sell a $10 product that pays out same percentage in prizes as a $20 product. So if you're a retailer in South Carolina and you sell their top ticket, you make 70 cents. If you're a retailer in Georgia and sell a $20 ticket, you perhaps make $1.40. So that's considerable difference in what your income is and what your payout is to your retailer person. So you need to think about your tickets and how you balance that. What the retailer is going to be compensated, which is you have to have them happy because they're your base. They're your hands and feet on the ground that are going to market for you. So I would tell you, whatever you do, you have to be able to explain it to them. And you probably want them to be a part of the process so that they are happy with whatever they think that their rate should be.
David, is that compensation rate something that once all this gets approved, a gaming board of directors or the private CEO group would set? You mentioned not being in the enabling legislation. So is the enabling legislation that there can be a commission charged, but leave that to management? Or is that a policy issue?
No, sir. Depending on who's drafting the legislation, it could be a statutory issue. Generally, what you would like is for your board to set whatever that compensation should be, giving them the flexibility.
Right.
So
thank you.
I guess my point is to make sure that in your enabling legislation that you allow the flexibility to the board to actually be able to make this type of decision. Some states don't.
Thank you.
If you could move to page 9, please. Mr. Chairman, I don't know how many presentations you've had, and so I apologize if I'm not going over what you need or.
No, you're doing fine. And if you miss something, the 12 of us will ask you. So go ahead. I would encourage you to look for the next 5 minutes or so to wrap up.
Yes, sir. I think I can do that. I got about 3 more slides. Vendor RFPs are probably for your incoming board, if you have one, are the most important things they will ever act on. I would tell you many states limit the contract terms for these RFPs. You really need at least a 10-year term to be able to maximize the best pricing you can get. Very important aspect here. A lot of states, not a lot, some have 7. Some states go out 20 years. I don't suggest that, but I will tell you, I think at least a 10-year procurement is something you need out of the gate to get your best pricing from a vendor. And these are all major RFPs. The draw system, you have 3 vendors, Interlot, IGT, and SGI. You'll hear their names a good bit, I'm sure. The instant side, you have SGI, Pollard, Banknote, and IGT, who all do a great job. And then you're going to want to hire somebody for your advertising services that'll be a local firm, I feel sure. It's not as important that that contract is 10 years, but you also have a banking services contract, which probably you get a best rate over an 8 or 10-year period. And then you have a couple of minor RFPs also that warehousing and distribution can be included in either the central gaming system or the instant printing services contract. Texas outsources all their field work to IGT through their RFP. So these are all things for the board to consider, but these are all major RFPs that you should be aware of that will occur should you have a lottery. If you would flip to page 10, please. And really, I just went over page 10 to emphasize again the 10-year period. It's just much easier. These are contracts and RFPs when it actually takes you about a 2-year period to change out a vendor once you have an online gaming system. I would compare it to a motor vehicle computer system. So it's very comprehensive and very hard to do. So if you flip to page 11, this is just a little bit about the games you'd want to actually start with. And this would also be left largely to your incoming board and the CEO to discuss and come up with a game plan for. But I'm sure you'd want to be able to sell Powerball or Mega Millions. There are 2 groups you can join. That's something you might have an interest in. The Multi-State Lottery Association actually has Powerball. The Mega Millions Consortium actually owns Mega Millions jackpot games. So you'll want to join one of these 2 games. So you'll want to have the ability to join multi-state associations in your enabling legislation. That's very important. Probably very important that you allow for international sales. We're trying to take Powerball international within the next 2 to 3 years. So to help the game with the jackpots, you have to increase your population base. So we're looking at perhaps bringing in the English or the Aussies. So that's still much up in place. But then you have your normal scratcher games. They go from $1 to $20 depending on how you roll them out. Pick 3 and pick 4 games are pretty strong games, and you'll see that's probably one of the reasons South Carolina has such a good per cap. They're very strong with the pick 3, pick 4 games, which are East Coast games. You go past the Mississippi, the games just fall off. It's historical games. But anyway, jackpot games will be good to you, but you have to have a strong portfolio of games that are sort of Alabama games. And those are your scratchers, because those are the base of what you can control in your portfolio. The major games, it takes us 6 months to a year to change. And as you can tell from what's going on with the world today with COVID-19, jackpots have fallen, and the players are not getting out to be able to buy those tickets. So I think scratchers throughout the country are very strong. So you need the most flexibility you can with actually releasing those scratchers and how you bring them to market. If you flip to page 12, these are just some per caps across the southeastern region. You'll see South Carolina has the draw games at about $5.50, and their scratchers are about $1.89. So you'll see that's probably a good measure for you, South Carolina, when thinking of what you're going to bring in per cap.
That's revenue to the state or revenue to the vendor?
That's your total revenue.
Okay.
And if you would, let's see, try to hurry for you. I think your projected sales will be about $1 billion a year, a little over that to begin with. Depends on what games you roll out and how you roll them out. Obviously, you're probably going to get somewhere between 25 and 27% return on that $1 billion the first year, which is projected to be about $280 million, I think, for your return. I think I set the number at 26%.
Total gross less the expenses.
Yes, sir. So I think that's a pretty good return. Commissions will probably run about $61 million to your retailers. All that gets taxed. So like I said, there are a lot of pros to your retail environment and a lot of economic opportunities that are afforded by bringing in a lottery that helps build on your infrastructure of your state and helps hopefully the students. I hear you're going for education, so I have my fingers crossed for that.
Well, let me just be clear about that. That has not been decided. We will not be the ones to decide that, but certainly education from a political standpoint would sell well in our state, but that's not yet been decided. So
Yeah.
since we got media here listening and others, that is not been in stone.
That's why I said I crossed my fingers.
Just a quick question, Regina Benjamin. Are any of these states have online purchases of the lottery?
Most of these states are moving to online sales of the lottery. So it is coming. It will probably be a requirement with Powerball in the next 5 years, just so that we can avoid people standing in lines, perhaps if we have another pandemic. But fairly sure Georgia, you can buy online. In Florida, I know even in New Mexico, I'm about ready to launch an online procuring system. So it is coming. If you look at Michigan, they probably get about 10 or 12% of their sales online. You can do it at different levels. Obviously, it might be that you only want to have certain types of games online, like Powerball or Mega Millions, but there are other lottery opportunities too, and those are things you'll have to think about in your enabling legislation.
Okay.
Hey, David, this is Carl Jameson. Quick question, and not to put you on the spot, but could you comment on states that might have the best, most flexible in enabling legislation? Some of those that are pretty good.
I've always liked Georgia's legislation. I think it's a good benchmark for most. Tennessee is fairly flexible also.
Okay.
This is Young Boozer. Let me ask a question about these numbers on the last page. These lotteries are all mature, and these are current, this is current performance, is that correct?
Yes, sir.
Okay. From startup to what date does it take to get to levels like this? What could we expect to see, or when would we expect to see our lottery hitting these kinds of levels?
I would think in year 2 you would be getting very close. It all depends on how fast you want to roll out certain games, sir.
Okay, thank you.
Do you have more slides, David?
I know, sir. I believe that is, let's see, one more, page 13, slide 13.
Lucky 13.
Yes. And I can't forget this page because it has responsible gaming on it. I think it's very important for everyone to play responsibly. It's something we took great pride in South Carolina. If you go to New York and watch one of their lottery commercials, I didn't think it was appropriate to bring that to South Carolina. So I would tell you responsible gaming is something that should be at the forefront of any decision that the lottery makes. And probably that is the most important aspect of the last page.
We actually heard from that group at our last public session that we in fact had. May I ask, the good news, we sort of have a white sheet of paper, a blank sheet of paper, although we do have some gaming in the state, bingo, if you will. If you have only, well, let me ask it another way. If you've got the whole enchilada, the lottery, your slots, your table games, your sports betting, is there a competition for the dollar that's out there? And does the dollar in Georgia for lottery only, I guess, is it different from the total dollar in a Mississippi who's now got lottery as well as table game?
You know, that's a very good question. I have 21 Indian casinos in New Mexico. So I would tell you that our players are, while they overlap, I'd probably guess maybe 20%. Those players are somewhat segregated to their sides of the board. A casino or a bingo parlor is sort of a destination event for a lot of people. They go and they enjoy it. Being able to pick up a Powerball ticket on the way home on a Friday night at a convenience store for a drawing is not something you generally want to go out and do. So the two are quite different. I will say, depending on lottery vending machines will, depending on what you decide you want to do, with your lottery will also impact the numbers that you saw on the page before, if I can add that. And I think significantly.
Questions? Well, David, thank you so much. I wasn't clear. I heard, I guess, in register, your position, are you on the regulatory side? You run the gaming in New Mexico for a private corporation? Exactly what's your role?
No, sir, I'm the CEO and we're a quasi entity. So we're a corporation. We have a board appointed by the governor, confirmed by the Senate.
Right.
And that's quite common.
Yeah.
Some states, South Carolina has it split between the Speaker of the House, the President of the Senate, and the governor getting a number of appointments. So
How big is your board?
It is 7. I would tell you, it is wonderful. 7 seems to be the perfect number. I had 9 members before, and it just seemed a little bit too big.
Well, as the mayor, I had 9 city council people, so I would agree with you. So the lesser the better. All
David,
right.
David, this is Liz Huntley. Do you have an opinion as to what's the better approach in terms of selecting such a board, or what you've seen to be more effective?
I think and I will say this, I think it's better that whoever the appointing authority is, does the appointing. If it's the governor, I think it's good for the governor to come up with like-minded people to be on a board of this type. I hope that's politically acceptable. You know, I worry about that too, because you don't want to make your governor mad. But I think the Senate plays a role, and with the confirmation, I think it's a good balance. But I do think that you want like-minded people appointed by one person, and that's just my opinion.
Do y'all have geographical distribution of board members?
We do ask that we are required to have an accountant, a lawyer, someone from security background. So we have those types of requirements so that we have a balanced board.
Yep. Other questions? Well, David, thank you so very much. We appreciate your time and effort, and you keep on talking about this Powerball. We'd like to be able to win the Powerball. So
you have to be able to play.
That's right. You know, unfortunately, I've never been in a position in any place where they had it to be able to buy one. So I never have had a chance.
Well, I will tell you, when you have a winner in Alabama, and you will one day, I don't know when, but they win maybe, you know, $700 or $800 million. I don't know what that tax amount is to the state, but you'll say, wow.
Well, that does bring me to a question. The numbers that you've given us and that we've seen with some of the official reports from other states. My understanding is if you won the Powerball, say in Georgia, which I think happened the last year or so, and there is tax to that state, is it also tax to that locality, the city and the county, and is that revenue included in the per capita number that you've talked to us about, or that we see comparative analysis?
It is included, but I don't want to get into tax law because I'm not an expert. But at the end of the day, you do have to claim it on your taxes. And I know as a New Mexico resident, I would claim anything I won anywhere on my taxes. So I think you get a refund from one state and a credit of some sort. So
yeah. So if your number said 270 or 280 million net, that would be exclusive of any winnings that any people in the state would have won that they would have to declare on their income, on their state income tax.
Correct.
Yeah. Okay. Anything else, guys? All right, David, thank you so very much. I appreciate that. The agenda calls for next steps for everybody's knowledge, depending upon the governor's position relative to meetings. I think technically we probably could have had a public meeting in person today. We chose not to do that. We're directionally looking at June the 5th to have hopefully an in-person next public meeting. And I will tell you that is our intention, although we've not made any contacts, to have at that meeting the Alabama stakeholders, if you will, have an opportunity to visit with us relative to what they're doing and what their expectations might be and what their desires might be in anything that we would recommend going forward. So you'll hear more about that over the next week or two. I will remind you the Secretary of State's website has all these notices for you at that point in time. Baker or Brooks, do you have anything else that we need to bring to the study group's attention before we sign off?
I can't think of anything at this time.
Brooks?
No, sir.
Any of the study committee have any other comments that would be good for the order? We've got Barney, Justice Harwood joining us. He has been selected by the state to be the attorney that would be assisting us, and we're delighted. We've had some chances to visit with him, and pretty impressive, his knowledge of gaming already, and we appreciate Justice that situation. We've also engaged Parka to look at some validations of some numbers that have come across, including these numbers that we heard today, to give us some order of magnitude sense of where we are. So we're moving in a good direction. We're not rushing, but we are moving at deliberate speed. And the next public meeting will be June the 5th. So stay tuned. Did I hear someone want to say something?
Well, this is just Regina Benjamin. I was going to say thank you for clarifying that we haven't made any suggestions as to where the funding should go.
Right.
Because
Absolutely.
I'm also a proponent of education, and I think that's important, but I'm also a proponent of healthcare, and we have to fund healthcare. So.
Yep. No, we know that, and that will be an opportunity at some point in time to have a full discussion, and I'm sure it will be discussed. So
yes.
Thanks all for your time this morning. We will see you along the way. Thank you so much.